everyone, and welcome to the call this morning for the SEC versus J&J Consulting Services Incorporated investor call. Today is June 13th, 2024. Before I get started, I do want to do a couple quick disclaimers. First of all, anything you hear today should not be construed as legal or accounting advice. If you have specific questions that are either legal or accounting in nature, I do recommend you reach out to competent counsel to discuss that. And any mention of any parties on the call here should be considered innocent until proven guilty otherwise. So just want to give everybody an update as to where we are on the case and kind of what's happening right now and what we anticipate happening here in the near future. So as everyone is probably aware, we are continuing to work on gathering and selling assets as part of this case, and we'll continue to do so, into the future. Right now, the primary focus of the receivership is on the forensic accounting. As we've stated in the past, there's a general lack of documents and information available, so we've had to recreate everything from scratch. That is why we've done a couple investor questionnaires, in addition to subpoenaing hundreds of thousands of pages of documents, including bank statements, checks, and other such financial information. Once we get the forensic accounting wrapped up, then our intention is to start the claims process to allow people to file claims, which will then ultimately lead to distributions. But now I'm going to jump into the specific questions that we have that the investors have sent us. First question being, just asked in general, do we need additional information from specific individuals in order to continue to move the case forward? Any information that we need, we will reach out to individuals if we have specific questions. We have sent out, as I said, 2 general questionnaires to investors and requested that they complete them. And we've taken that data and used that as part of our forensic accounting project. We continue to also work with the defendants in the case to gather additional information as we need it, and we'll continue to do so into the future as well. How long do we anticipate the total process taking? That's a good question, and it's a question that may be difficult to answer because there's a lot of factors that will control how long ultimately things take. One of which being, litigation against third parties, so banks, net winning investors, third parties who got preferences and other such potential targets. So depending on how long those things take, that can affect the total outcome of the case. However, it is our intention to begin making distributions when, once we get the claims process done and the court approves it. And so we can start making payments. And it's likely that we'll see 2, 3, or even 4 payments made throughout the pendency of the case as it moves forward. Next question is, based on my interpretation of the financial reports, interest accrued over 3 months is approximately $200,000. So the interest is accruing on the account. That does sound approximately right. We've been attempting to figure out ways to get a higher interest rate return on the money while still keeping it insured and protected. We thought we had come up with a solution that I was looking forward to announcing to you guys, and then I got a call just before this call to let me know that that solution would not work. So we are still continuing to work on that. We think that in the next week or 2, we will have a final solution that will allow us to continue to draw even more interest, with the hopes of offsetting any cost to the estate. Next question is, why is the receiver made it illegal to go after the parties in this case? So the receiver, myself, I have not made it illegal to go after the parties in this case. The court has done so. And there's a good reason why they do that. Because of the number of investors involved in this case, if there was not a freeze order in place that would prevent people from suing, we'd end up in a situation where we could have hundreds or even thousands of people suing an individual. And the cost of litigation, for all those different parties, plus the cost of the defendants who get sued, would be astronomical. And so it's far more efficient to have one person who's responsible for suing the parties that are involved in the case. So there's only one set of legal bills, and it'll just be significantly cheaper and easier. Not to mention, it's our duty to make sure that when we do collect money, that it goes out to everybody proportionately. And we don't want situations where one investor got, sued and got some money back and another investor didn't. And then we end up with investors who, ultimately would have gotten paid back in different amounts. And so we're trying to streamline the process to make it cheaper, to make it easier, and to make sure that it's fair. Next question is, have you heard some of the promoters are starting to pay investors back out of their own pocket? Anecdotally, I've heard that. I have not seen any evidence of it occurring, but we have reached out to a variety of different parties, letting them know that that is not to be done, because essentially what they're doing is creating a preference for those investors that is subject to being clawed back and distributed out evenly. And so, if you do know of instances like that, please do let us know. We are asking that the parties involved, we will seek to get that money returned to the receivership and distributed out to everyone equally. Next question is, why does the feedback on these calls sometimes feel generic? The feedback on these calls is based on the questions that are answered, and so we're doing the best we can to answer them. However, we do have to be careful because we're in litigation with a number of parties to make sure that we don't say anything that either can be used against us in that litigation or could damage the strategy of the litigation. And so we do have to be more careful with what exactly is said and the specifics of it. Not to mention, there's certain things that can be said or can be done that can affect the ability to do litigation in the or the timing of that litigation. Next question. Will you send acknowledgement of receipt of our questionnaire submissions or an agreement with our funds? So we will not be sending any acknowledgement with the receipt of the questionnaire itself. However, when we do the claims process, there will be a system in place to give a receipt related to the filing of the claim. And so because that is going to be obviously the most critical piece to ensure that you get a claim in place for payment when the time comes. And so those will be acknowledged in a definitive fashion. Next question: what assurances do we have that there will be a resolution soon, and that we can be made whole and not feel victimized all over again due to the cost and length of this process? So I can tell you right now that this will not be done soon. It's not going to be done in the next few months for certain. Because of the length of the forensic accounting project, because of the lack of records, not to mention the litigation. These cases do take a significant amount of time. It's not uncommon for them to take 3 to 5 years to get to completion. Now, that doesn't mean that that's how long you're going to have to wait to get paid, because as I said, after the forensic accounting is done, we'll next move on to the next piece of it, which is the claims, and then a distribution motion after that. And so there will be payments that will begin before the case is over. Let's see. The next question is, where do I file a complaint on the receiver? If you'd like to file a complaint, you're welcome to do so in my office, or you are also welcome to file a complaint in the case in which I was appointed, so the federal district court case. And so you're welcome to do it in either place, and we look forward to hearing any feedback that you might have. The one thing I would request is if you have a specific complaint that you would reach out to us and give us an opportunity to discuss it with you. Next group of questions has to do with defendants and the various parties. Will any identified aggregators or solicitors be named as related defendants in the ongoing proceeding? The decision whether or not to add defendants to the SEC case is up to the SEC and only the SEC. We provide lists of parties that are involved and the amount of money that has been collected, but ultimately it's up to them to decide who is and is not going to be a defendant in the case. Next question: did any of the defendants or other recruiters ever invest in contracts through Beasley? Yes, we do know that a number of the defendants put in money themselves and other promoters that put in money. So the answer to that is yes, that they also did put in money. When will the other partners be charged with a crime? What evidence needs to be brought forward in order for that to happen? So criminal charges are up to the Department of Justice and the U.S. Attorney's Office in Nevada. So we don't know if anybody else will be charged with a crime or what that time frame looks like. The evidence that needs to be brought forth, it again is up to the Department of Justice. The general rules, they have to be able to prove the crime. And so if you have specific questions related to the criminal side of this, we have nothing to do with that. But I would recommend that you reach out to the U.S. Attorney's Office in Nevada if you have questions. Next section has to do with litigation. What is the status of the Wells Fargo mediation? So we had a mediation with Wells Fargo in February. It was February 29th of this year. That was our second mediation that we'd had with them. And we were unable to settle at that time. We are continuing to move forward towards a trial. However, I do believe that there will be a number of instances in which we try to continue to mediate this claim as we move forward. We are hopeful that we can get this resolved short of litigation or ultimate trial. But we are looking out for the best interest of investors, and we're fighting for investors. So we are not willing to settle at a number that we do not believe is commensurate with the damages and harm done to investors. Next question, is Wells Fargo going to be held liable for any of this? I think that that kind of answer that I tried to answer that in that previous response. We do believe that Wells Fargo should be held liable for their actions in this case, but the ultimate outcome of that is up to the trier of fact or a decision in or settlement and mediation. If the bank is liable, is it the amount lost, or could there be punitive damages, and how can that benefit investors? So if the bank is ultimately found liable, obviously we will be going after what we believe are the damages or the harm to investors. And we can and I would intend to seek punitive damages if available to us. And punitive damages obviously provide additional return to investors, and so that could be very, very beneficial. Just so everybody's aware, the money that is earned through the litigation against people like Wells Fargo and others, is money that goes directly to investors outside of any type of fee that we have to pay the attorneys for doing the work, any kind of contingent fee that we have to pay. Everything else goes directly to them. The receiver does not get any benefit for the amount of money that we settle for in any way, shape, or form. So any damages or any punitive damages recovered will go back to investors. Do investors have to approve any possible settlement you reach with Wells Fargo? The simple answer is no. The real answer is, the receiver was put in place. I was put in place here in order to oversee the case and do these things for the benefit of investors. And I don't even have the ultimate say in the settlement. Ultimately, it's the judge who's monitoring the case who will have the ultimate say as to whether or not any agreement will be approved or not. And so, and in that case, investors will be given the opportunity to object if they don't think that the settlement is fair, and have their day in court to be able to express their feelings on that. Next question is, what percentage chance do you give for Wells Fargo recovery? I would say that there's I don't believe that there's any chance that we won't recover from Wells Fargo. Now, the dollar amount, that is a different story, and that's going to be based on the facts of the case. And we're some of those facts are still coming out. We are attempting to get copies of emails and text messages and other documents that will help strengthen our case. And the more that we get in those from those different documents, the better the case becomes, and the higher the settlement value will be. Will we have to wait until Wells Fargo settles to put in claims, or will there be a separate claims process for that? So no, there will not be a separate claims process for that. So the Wells Fargo litigation money will go into the receivership estate and will be distributed out as part of the pro rata distributions that we do in the case. So there will not be a separate claim process for that. As I said, we intend to start the claims process right as we wrap up the forensic accounting. One of the benefits of the forensic accounting, for those of you who are not aware, there's multiple reasons that we do it, but one of the biggest reasons we do it is it's very difficult for investors to be able to pull together all the financial documents, copies of emails, records, things like that, that can make it hard to prove the claim. And then once they do gather all those, then somebody on my team would have to go through those and evaluate them and make a determination based on those documents. So having to do the forensic accounting anyway makes the process much easier, because we will have a good idea of what everyone is owed, and that will simplify the process much better. Let's see, next question. What is the process and time frame for this Wells Fargo case? So the Wells Fargo is part of a class action litigation case. Those cases can take years. We are moving the case forward. We have done discovery. We continue to do discovery. There are depositions that have been done and will be done. And so it will continue to move forward. I anticipate that we will probably mediate with them at least one more time this year. But we continue to push that forward to try to get it done and settled. Next question. How did it come about that one of the largest financial institutions in the world missed thousands of $100,000 plus deposits and transferring coming in and out of one account to another in even round numbers for years and didn't catch or question it at all? That is a very good question, and that is much of the contention for our litigation against Wells Fargo and believing that they knew or should have known that this was occurring. And I don't have an answer to how or why they didn't, but I do believe that those are the facts that will benefit our case ultimately in the end. What is your current level of confidence that we receive any money from the Wells Fargo lawsuit, and how much money would be recovered? So the amount of money that would be recovered is up in the air. Like I said, I do believe that we will be getting money from Wells Fargo. I don't believe that there's really any chance that we would get nothing. I do believe that they are liable for what happened. That's the reason why we filed the litigation. And I do believe that the sum will be substantial. Now, whether that is, what that number ultimately ends up being is a question. We think that number, we think that the damages to investors and the harm to investors is going to be somewhere in excess of $160 to $180 million and could be as high as in the $200 million range. That number continues to be refined as we work through our forensic accounting, but we won't have that final number until that accounting is done. However, we do believe that is the damages in the range of damages to investors. Last question is, how many banks are you going after? So the ultimate decision on how many banks we're going to go after has not been made yet. That is one of the other things that comes from the forensic accounting is support for litigation against third parties. So we need to figure out who benefited from it, who was responsible or who allowed these types of things to happen. And then we will then evaluate the type of claim we have against them and determine whether or not it makes sense for the estate to go after those parties. I am pretty confident that there will be other banks or financial institutions that we will be going after in this case. But I can't tell you yet who they are or the dollar amounts that we're going after until we finish this forensic accounting. There will also be other third parties as well. In addition to just financial institutions, there's potential professional malpractice that we may be looking at, as well as clawbacks against third parties who got money that they weren't entitled to. Next question. Next group of questions has to do with assets. Have all the assets been recovered? No is the simple answer. There are still some assets out there. Part of it is that we, some of those assets are assets that we continue to recover as we find them, or that we continue to work through a variety of issues on them. But no, the goal is that there are more assets and that we will continue to recover them. Some of the defendants have made agreements with either the SEC or with my office regarding certain assets, to where maybe some of them we've taken and just sold, and some of them we will continue to hold liens on. And protect the asset, but have not yet taken possession of them for a variety of different reasons. But we do continue to collect assets, and I would continue to speak with my office if you guys know of specific assets. So if you've heard of something and you're just unsure if we know about it, please do reach out to us, because even if we do, I'd rather you tell me, or I'd rather be told 10 times about something than never be told about it, because any potential asset is additional recovery for the investors in this case. The next question has to do with the breakdown of assets included in the report. We do file detailed reports every quarter regarding the assets that we collect, how we sell them, what we sell them for. We unlike in a bankruptcy, we're not doing fire sales. We are attempting to sell everything in the ordinary course of business, including the real estate and some of the other larger assets that we've had, and have done a good job of maximizing the value on those items. Next question. Is it true that you have almost $200 million in cash, investments, and assets, or is this just from Shane Jagger and J&J Consulting? So no, the amount of cash that we currently have is in excess of $70 million. We also have an additional $20+ million in other assets. And then we, of course, have the assets that have to do with the litigation that's ongoing, the other litigation that we anticipate filing, including clawback actions and preference type actions as well. So that number will continue to grow. Next question, why is the money not being held in treasury bills and where is it being held? So it is being held in a receivership account that is currently guaranteed. As I mentioned earlier in the call, we are looking at ways of getting the money into a higher interest return, but yet still protected. It's a real fine line between wanting to maximize the return that we can get and making sure that the money stays safe. The banks that we use are East West Bank. It is a very stable bank, a large bank, and that we have full faith in. But as you guys are aware, back in the 2000s, we saw a number of banks go under. We've seen a few banks go under in the last few years. So we need to make sure that this money is safe and protected for all investors. But again, my hope is that we will have an answer and that we will actually be able to get these into a little bit higher interest rate accounts here in the near future. Let's see, what was the eco battery litigation? So that is a good question. You guys may have seen stuff that's been filed related to that. So eco battery was an investment that was made by one of the defendants into a lithium-ion battery company. He had invested both as an owner, buying equity, as well as putting money into promissory notes. That defendant also had some friends and family that also invested in eco battery that were not investors in J&J at all. And as part of the process of recovering the money for the benefit of investors, both the promissory notes and the equity portion of it, when we recovered that, we recovered all the money that was owed to all the investors that were part of Eco Battery through that defendant. But unfortunately, that money did not belong to J&J Consulting or the estate at all. So the little bit of money that belonged to specific investors that were not J&J investors that were not part of this case was returned to those investors because it belonged to them and them only. However, the defendant money that we collected for the promissory note and the equity all went into the receivership estate and will be distributed out to investors. How much more money does the receiver need to collect in order for the investors to get their money back? So we have enough cash right now to where we would feel comfortable doing a distribution. However, until we finish the claims process and know what everybody is owed, we can't do a distribution because I can't send out money to people until I know what they're owed. This is complicated by the lack of records, not only from the financial side of it, but we end up seeing names. So we get bank statements, we get wires, we get checks, and we see people's names, and we got to figure out, are those people an investor in J&J? Are they a vendor? Was it something that just one of the defendants bought from a third party? Or was it legitimate business? Because some of this money went through other bank accounts that had legitimate businesses tied to them. And so we're having to build a complete list of who everybody is in this case. And we're up over 2,700 different entities with at least 1,400 different individuals. And so we're having to figure out exactly what that would be. And so we're working on putting that together as part of the forensic accounting, and that's what makes it difficult because we know some of the dollar amounts, right? We know that if $80,000 or $100,000, is the dollar amount, it's most likely an investor money being brought in. But sometimes investors will pool together where people may have put in $5,000 or $10,000 and pooled a bunch of those together in order to meet the minimum investment. But we also know that some of those $100,000 payments could be down payments on houses or cars or something else as well. And so we have to break that out and figure out what those really are in order to be able to fully account for that money. I personally have been involved in a number of Ponzi schemes. I've done work in the Bernie Madoff Ponzi scheme, the Alan Stanford Ponzi scheme, the two biggest Ponzi schemes in the world. And I can tell you that the forensic accounting in this one is more complex due to the lack of records and the fact that there are so many entities involved in it that we are having to trace and basically build from zero. We kind of liken it to putting a puzzle together without knowing what the puzzle looks like and not even knowing if we have all the pieces. And so it's difficult because that's what we're forced to do. But in order to make sure that we get everybody the money they're owed and we're able to collect all the money that's outstanding, we have to do that. And the money that we spend in this action is going to be returned many, many times over due to the litigation and other pieces that are involved in it. A question about forensic accounting. Has the receiver investigated anybody involved in collecting, pooling funds from third parties and investing said funds with J&J Consulting? Yes, so we had, as part of this, we have been breaking out the poolers and looking at the monies invested. We don't think we know who they all are. We're not sure that we know what all the dollars are yet because we have not finished the accounting piece of it. But we have been going through it and dealing with it. In fact, some of these poolers, could have had up to 80 or 100 different people that were invested with them, which of course complicates the forensic accounting itself. But we are breaking those out as we come across them and are getting them done. That's one of the reasons we sent out the questionnaires, in fact, is to try to figure out exactly, who was owed what money, and whether or not the investor that we see in the record is actually the investor, or if they were just a pooler for a bunch of other investors, because we want to make sure that that money goes back to the right parties at the end of the day. When will the forensic accounting be done? Is it already completed? It is not completed, and when it will be done, we anticipate filing our forensic accounting report in the first quarter of 2025. It doesn't mean that we won't be done with the accounting itself prior to that, but there's still a lot of question marks. We're working on a project that doesn't have a definitive end to it, because as we go through this, we discover additional bank accounts and additional monies. From the beginning, the SEC, was saying this is about a $450 million fraud case. We believe actually by the time we're done, we're going to be closer to $600 million in total amount invested in the scheme. Next question is, how did deposits withdrawals get to 4.7 billion when 500 was the number lost? So in the process of reviewing accounts, money didn't just necessarily go into one account and out of another account. If it had just done that, then it'd be a pretty clean, easy match to the number of investment. But because money would be put into one account and then transferred to another account and maybe another account after that, and then finally into the final account, each time that money moves, it creates a record in the system. And so we have $4.7 billion in transactions, but we do believe that the money invested is going to be somewhere between $500 and $600 million in total. The next question is, why not go backwards with your forensic accounting and focus on the people that were the last group of investors? We don't work from the front back because it doesn't tell us the whole story of what happened, and the fact that people may have invested early but still been invested 5 years later. And B, all investors are treated equally in a receivership. It is a case in equity, and so everyone will be treated equally. So it doesn't really matter when you invested. It's based on the total amount of money you put in and the total amount of money you got back. So next group of questions has to do with clawbacks. Have investor winners started being asked to pay back? Has anybody paid back? So we have not yet gone after investors and asked them to pay back money because the forensic accounting is not yet complete. We have to complete that process before we actually know who net winners are. Sometimes it may seem like somebody's a net winner, and then as additional transactions come in, you ultimately discover that they're a net loser. So we don't want to sue anybody who is a net loser, obviously. That goes against our legal system and really affects our ability to be able to do this type of work. And so we need to make sure that we understand and that it's right. What specific actions have been taken to recover from some aggregators or solicitors who are involved in the scheme? So we've made contact with some of the institutions that we know of that did get money out of the scheme, including a church and some other organizations, and let them know that we will be seeking that money back. Once we figure out exactly how much money we think that is, and we will continue to do so going forward. We will have to get permission of the court to file litigation against those parties, but we intend to do so, right along with when we're finishing the forensic accounting and know what the final numbers are for everyone involved in the case. When will the clawbacks commence for those that made fake profits at the expense of others? That will occur after the forensic accounting. Claims process. Can you confirm that my claim has been filed? No claims have been filed to date because we have not. The court has not authorized a claim process, nor has there been a claim form. Some people may be confused because before the SEC case started, there were some bankruptcies that were filed, and people filed claims in those bankruptcies. However, those claims are not claims against the receivership estate, and we will be asking that everyone file a claim in the receivership once the claims process begins. Next question. Once the forensic accounting is done, how long does it take for the claims process to start? So typically, we like to start the claims process, or at least file the motion to the court to allow us to start the claims process right on the heels of the forensic accounting. We need to wait till we're done. That way we have a good understanding of what the case is and how it works, because we need to make sure the claim form fully covers every possibility that could be out there. But we do intend to get that done, like I said, right on the heels of the forensic accounting, with the hope being that it would start very, very quickly afterwards. Once the forensic, let's see here, sorry. Is there an order in which claims are taken? No, there is no order in which claims are taken. Claims will be accepted from everyone, at the same time. How will the recovered funds be distributed amongst investors and creditors who provided funds to aggregators, solicitors in the case, and not to J&J directly? So our general rule is that we provide any investor that made investments that we intend to pay back the investors directly and not poolers and aggregators. So if you invested through a pooler or an aggregator, you need to make sure that we are aware of that and that you file your claim and let us know who that pooler or aggregator was, because our intent is to make sure that the money goes back to the investor and not to the pooler or aggregator. Next question. Let's see. How will you keep everyone honest as to the amount they lost and the amount they were paid out? So that is the primary purpose of the forensic accounting, is to make sure we know who put money in and who got money out. There will be some complicated cases because there were people that invested cash or traded assets, but those will be dealt with on a case-by-case basis based on the information that we have available to us at that time. The claims process will lay out how claims will be audited and judged. But just know, as part of that process, when you file a claim, if for some reason we disagree with what your claim is, we're not going to just deny it or recommend the court deny it and move on. We will reach out and work with investors to try to figure out why they think it is that they have claims and what those claims look like. And only if we can't reach a final agreement, well, then we'll file something with the court saying that we think that there is an issue with this claim. So there will never be a surprise as to how we intend to treat your claim or what the process looks like, because you will be given ample opportunity to talk about it and discuss it. Why do you think that people who were first in the fraud should have a claim? So any investor who put money in should be entitled to a claim, whether they were in the first days or in the last days. It doesn't really matter, because all investors that have lost money are considered victims of the case, whether it was early or late. In fact, some people would argue that people who invested early on and kept rolling their money over are bigger victims than people who put in later or got most of their money back. But again, we deal in a court of equity, and typically investors are treated equally across the board, and that is what is likely to happen in this case. We have not made any recommendations on how a distribution will occur. We've seen people print stuff saying that we have. We absolutely have not. We don't make those determinations on distribution until we finish the forensic accounting, and oftentimes until we're into the claims process, if not near the end of the claims process, because we want to understand how people were victims and what that looks like. Because whatever distribution methodology we propose to the court, we do want to make sure it's the most fair for everybody involved. And in order to make that determination of what is most fair, we need to be able to look at everything. And so that's why we have not, we have not talked about what a distribution looks like. Typically they are a pro rata distribution where everybody gets an equal percentage across the board. But in some circumstances that may be slightly different depending on the facts of the case. But again, until we get to that point, there is, no decisions have been made. And keep in mind that, my decision on claims, whether I think a claim should be approved or not, or what way I think a distribution should happen, is only a recommendation to the court. Ultimately, the court decides what is going to happen in those cases. And again, investors will be given an opportunity to object or to discuss them if you have specific questions related to them. Next group of questions has to do with the distribution process. How many phases of distributions are anticipated? We don't yet know, but we do anticipate that there will be, I could almost certainly say that there will be at least 2 distributions, and there could be 3 or 4, depending on the timing of some of the litigation and somehow how other things work out. We get no advantage to hold on to the money. In fact, we want to get the money back into the hands of investors as quickly as possible. So we'll continue to do that and work towards that goal. And so that means that if we get a big chunk of money, let's say we settle with a bank and we get a sizable payout, we're going to want to distribute that money right away. So once we get the first distribution order done by the court, subsequent distributions don't require court order, because the methodology has already been set up. And so if we get a chunk of money in the door, we can just distribute that money out, and usually, within days or, a couple weeks at the most. So we will get that out, as quickly as we can, because we know that investors want that money and need that money. What is the total amount estimated that is needed to make everyone whole? That is the number we don't know yet. That it does continue to move. We think that it's like I said, it's certain that it's in excess of $150 million, but whether it's 180 or 220 or 240, we don't yet know, because again, we continue to work through some of these different ways in which people invested, including cash and buying out of other investors, which complicate the number, because it's not a simple money in and money out analysis in the account, because it did not necessarily flow very linear. It went to all these different accounts. Let's see, how will you prioritize which investors receive payment first? Again, typically investors are not going to be prioritized, as to other investors. It is usually a pro rata distribution amongst all investors. There are no priority classes of investors in a receivership case. Let's see, will there be any consideration for investors who never got their money back over investors who did? Yes, as part of the claims process, and again, this is ultimately up to the court, but typically it is done on a money in, money out basis. So if you were to put in $100,000 and have gotten back $50,000, you would have a $50,000 claim. Whereas somebody who put in $100,000 and never got out any money would have a $100,000 claim. And so that's how that adjustment is done. Next question is, what thresholds need to be reached to start making a distribution? We just have to have an approved distribution order by the court, which requires an approved claims motion by the court, which requires the forensic accounting to be finished. And so that's why the big push right now is for this forensic accounting and getting it done, because of all the different things that rely upon it. Let's see. Are you anticipating any payments to be made in 2024? I would say that it's very, very unlikely that any payment would be made in 2024, because of the fact that we have to finish the forensic accounting and we have to go through a claims process. And the claims process is typically held open by the court for 90 to 120 days to allow people to file claims and make sure that everybody gets notified. So given just that time frame alone makes it impossible really to do a distribution in 2024. But our hope is to get the claims process and the distribution motion and all that done, in 2025. So distributions will start to occur in 2025. Have you released any money to investors yet? No, we have not. If I close my investment bank account, how can I update my banking information in the event of getting money back? Since we have not done the distribution motion yet, we have not determined if we're going to be sending checks or if we're going to do wire transfers or ACH or some other form of payment. Once that's determined, we will then seek that information out in order to make sure that payments are made appropriately. If you invested through an LLC and that LLC no longer exists and you want payments made to you personally, we just need to make sure that that information is clear on the claim form. So we'll ask you for the entity that you invested with, but if you need it made out to some other, some other name, please do let us know, and we can work through that. Obviously, we would just need proof that you are the person entitled to make those changes. So if you had an LLC and you were the managing member, obviously, then we can accept documentation from you saying that it's no longer going to get paid to the LLC and should be paid to the member instead. Let's see, what is the likelihood of anyone collecting on their losses? Everyone who was an investor who lost money, as determined by the court, will get paid back. Now, how much that payback is, we don't yet know, and we won't know until we finish the litigation against the banks and the clawback and all the other litigation. But everyone will be getting a portion of their loss back, and that portion, we don't know what that percentage will be. And in receivership cases, we've done cases where it's as low as 5% and as high as 100%. And so it really does vary, and there are a lot of factors that are outside of our control, including litigation against third parties, collectability of litigation, and other such issues. Will we have penalties or extra tax payments with distributions? So again, this is a tax question, and so I cannot give you tax advice, but what I can say is that when we return money to investors, we're returning principal to them. We're not returning interest. So it's a return of capital investment, and so that is taxed differently. But as to how that affects your specific situation, you'll want to talk to a tax preparer on that. How much total is in reserve right now that could be distributed? So the amount of money that's available today, as I said, I think is in excess of $70 million right now. How much of that could be distributed? We would obviously need to talk to our tax professionals to see if there's any tax liability that we are looking at, because we would have to withhold for tax liability. But we do anticipate if there was any, it would be fairly minimal at this point. And our goal is to get as much money in the hands of the investors as quickly as possible. Next group is just about contacting us. So if you don't or haven't already, the first thing I would always recommend people is please just go to our website, which is jjconsulting-receivership.com. And this information will be copied into the chat. But again, it's jjconsulting-receivership.com. There is no ampersand between the two J's because an ampersand can't be used in a website name. So it's just JJ Consulting. The email is contact@jjconsulting-receivership.com, or you can call us at area code 702-832-2299. Now, the one thing I will tell you is after these calls, after we hold these investor calls, we do get an influx of calls. So please do be patient with us. It may take us a couple days to respond back to you, but we will get back to anybody who reaches out to us. Email is the preferred method, but if you'd like to call, you're welcome to do so as well. But I would recommend that people go to the website. If you haven't already done so, please register. That will get you on our email list. We don't send out a lot of emails, but we do send out emails from time to time, and they are typically important. We do host all the court pleadings, or at least all the pertinent court pleadings on that website. So you can go there and you can see what's being done in the case, and continue to be caught up that way. We also post our reports there that we file on a quarterly basis. And so if you have any questions, you can start there. But if you have specific questions, please do feel free to reach out to us. We are here to assist and answer questions. And we want to do so. And so, I would encourage people just to go ahead and to reach out to us when they can. I'm going to take a couple minutes to look at the chat just to see if there's any calls that came in or any questions that came in that I can easily answer in the little bit of time we still have going on. There was a question about the Wells Fargo settlement. Due to the fact that everything that's happened so far has been mediation, I can't get into the details of it because we can't discuss what happens in mediation, but just know that we're diligently pursuing a claim against Wells Fargo and do believe that we have a great claim and that there will be a significant recovery for investors. Can you schedule an in-person meeting with claimants so we can get more details on the difficulties you're having quantifying the total loss and the number of people who have claims? We are always happy to meet with people, whether it be via, a telephone, a video call, or even in person. So if you'd like to do that, we're happy to do that. The only thing that I would just caution you on is just keep in mind that the amount of time that we spend in those conferences and calls is money that is billed to the estate and ultimately will reduce recovery. It's pretty slight, but just know that that we want to be very careful about it. We try not to do things that that don't need to be done. But if you do have specific questions and feel that an in-person meeting would be helpful to answer those questions, reach out to us and we can get that scheduled. Let's see. Can funds be held in U.S. Treasury bills? So because of the nature of these accounts and the way we have to insure them, we are, as I mentioned earlier, we are attempting to figure out a way to get them moved to where we can get a higher interest rate on them. Again, we thought we had figured out the way to do it and it didn't work, but we are still working through that. And my hope is to get that done in the next week or two. I've made it a top priority, and and we continue to try to figure out ways to make this work. This high interest environment that we're in right now is pretty unique, and so we want to try to take advantage of as much as we can. Question: why hasn't there been disclosure of all the names of the promoters and net winners? So we haven't done that yet. Number one, because the accounting's not done, and so we don't know for sure that they're net winners or net losers. We don't publish those names until we won't go after those people or even publish any information related to it until we're certain that they are winners or losers. And once we determine that they are winners, we will seek permission with the court to go after those parties. And depending on that, there may be specific names in there, or there may be more general information. But we're going to do what's in the best interest of the estate in order to be able to maximize and collect as much money as possible. There's questions about the pest companies. Just know that we are in the process of investigating that and working through that. but we can't really speak to what's currently happening in that instance. Let's see, questions about pursuing individual claims. So again, while the case is going on, the court has put a stay of litigation in place. The receiver will be going after all the parties. If we make, if I make the determination that there is a party that we're not going to go after, and for whatever reason it may be, that may be an opportunity then for somebody to seek relief from the court to file an action against that party. But up until that time, there is this prohibition against litigation against parties for the reasons I mentioned earlier. Questions about fees and supporting documentation. So on the website, our report and our request for fees are all there with all the time billing. So if you have specific questions, you're welcome to take a look at that. And just know that our fees are reviewed by everyone in the case, the defendants, the SEC, and the court very, very closely. Let's see, can we get some kind of formal acknowledgement from you that we know you're in the records and in line to get our funds returned? So what I would say is that we're not sending out notes to people saying, yes, we know you're an investor until we get to the claims process, at which time we will be sending out notification. But even if we don't think that you're an investor, but you've signed up for notifications on the list, we will still send out a claim form to you so you can review it and file a claim if you think that you're owed money. And so that will be open to everybody at that time. Let's see here. It looks like I'm just trying to see if there's any other quick questions that we can cover that we haven't already talked about. It looks like we've pretty much covered all the questions that came in that we can't answer at this point. Let's see. There's a question about somebody stealing cars and going to jail, but these guys not going to jail. Again, those whether or not somebody goes to jail or who is ultimately charged in this case is outside of my purview. In fact, I'm not a party. One of the big misconceptions is I'm not even a party to the case. So the plaintiff, the SEC, and the defendants, in the civil case, have their case, and then the criminal side is done by the Department of Justice and the U.S. Attorney's Office in Nevada. So if you have specific questions about that, I would recommend you reach out to them. We don't have any association with them. We do talk with them from time to time about a variety of issues that happen in the case, but we do not work together on these cases and really have no inside knowledge as to what's going on in the case. So if you have specific questions, I would recommend reaching out to them and asking them specifically. Otherwise, I thank you guys for taking the time for this call. We will do another one of these next quarter. I hope to have more news for you at that point as to what's happening with Wells Fargo and the variety of different things that we've talked about, including the interest that we're attempting or the account that we're attempting to move the money into to draw a little higher interest rate on. So we will update you guys next time. But if you have specific questions, please do reach out. Again, the information is in the chat. I recommend you take down that information quickly because as the call ends, that information will go away. So again, thank you, and again, reach out to us if you have any questions. Thanks.